Good evening. This is Dane Parcel, and this is my submission for Module 12 for EDL 850, titled Tort Liability in Education. What is a tort? A tort is a civil action or wrongdoing that results in injury to another party's person, property, dignity, or even their reputation. There are two separate types of torts. The first tort does involve intentional tort, such as assault, battery, defamation of character, libel, which is the written form of defamation, and slander, which is the verbal form of defamation. It may also include invasion of property, mental distress, and false imprisonment. The second type of tort is unintentional, which is negligence, falls under that category. The term tort, basically in the field of education, really goes down to student safety, keeping students safe, keeping them from harm, instructing them of when potential dangers may occur, and that kind of goes along with our teachers' duty. The view that's held by the courts as they discuss and they handle cases that are related to tort is that teachers really have three basic legal duties. Number one, to instruct students. That may be on the curriculum or on the dangers. Number two, to supervise, be present, and be proactive. And number three, to provide safety. So in those times when there is safety needs, teachers are able to step in to provide the safety that is necessary for students to move forward. The next few slides discuss several different court cases, and each of these court cases does have some type of tort liability relayed to it. The first one is called Mitchell versus Cedar Rapids Community School District, and this one kind of has a connection to me simply because it does involve a student with a disability. Being a special ed teacher, I kind of related to some of the aspects of this case and trying to figure out what should have been done and how this could have been solved or not have occurred. But in this case, a ninth grade special ed student, and they gave her the initials DE, has an IQ of 67, has an IEP, a functional level of third grade. She is a student that rarely is without adult supervision, and due to instances where they have seen her with another boy, staff members do believe she has a boyfriend. So some additional background to this case is that DE asked her mother to go to a friend's house after school one day. Her mother agreed to that. However, DE decided, I'm going to go ahead and skip the last day of class. The last hour of class, actually, instead of waiting till the end of the day. So DE, along with the suspected boyfriend and a friend, went to the friend's house. Now, I am not sure how the incidents went forward, of course, from there. However, DE was sexually assaulted by the suspected boyfriend. The school district has a computerized system for recording unexcused absences. So upon DE's absence for the last hour of the day, it was recorded. However, DE's mom, due to the computer program, did not receive notification of her absence until after school was over. And so she did not know that DE had skipped the last hour of the day. Once she had found out of the case, she did go find her daughter. And it was a year later when the daughter finally did share what had happened to her. The boy was suspected of, or the suspected boyfriend did plead guilty to sexual abuse. And then the mother took the school to court, where she received $500,000 in damages. 70% fault of that was to the school, and 30% was to DE. The basis for that was the school had a failure to notify the mom prior to school ending that her child was skipping that last day. There was also not evidence that the teachers and the individuals that worked with her looked for her. So as a result, the case did go to courts, and she did receive monetary benefits from this case. In terms of reflection, some of the reactive issues, if that were to happen at my school, I would hope that my staff would know my policies that I've set forth and would realize that a student is missing, especially a student that is supervised quite frequently during the day. Some of proactive measures is I would look at that computerized program and see if we can't figure out a way to get parents to be notified during school. And professional ethics, I think it's important that as teachers, we will follow procedures, communicate issues, and be informed of issues so that we can make the appropriate decisions to avoid situations such as that. And that's kind of that professional ethics really does go with almost every case that I have. Following procedures, communicating, and being informed. The second case is Johnson Johnson versus the School District of Millard. And in this case, a first grader named Robbie Johnson was injured while attending his music class. They were singing and playing the game London Bridge, which requires the students to hold hands, and a third child is within your hands, and you're swinging back and forth, and then London Bridge falls down. And in that aspect, the teacher did explain to the students, which keep in mind they are first grade students, of some of the dangers about this activity and not to be silly. However, this young man, Robbie, was in the middle of two children and they were getting aggressive, and the two children let go and Robbie went flying into a bookcase. As a result, he did get some injuries up into his eye, and he was permanently disfigured. And so the parents took this court case to trial and basically said the teacher was negligent as to supervising, because the child said that the parent, or the teacher, was having their back towards the students as they were playing the game. And since they were first grade teachers, the school or the teacher was held liable in this case because they should not have been unsupervised, being first graders, and being just introduced to the game. And so, as a result, that teacher was held liable. The third case, before I get to that one, some of the reflection on that case, the reactive measures, I think it's important that an accident plan would be completed, and interviews with the students and teachers should have occurred. Some proactive measures would include myself as the building leader specifying the importance of supervision and not turning your back to students. That's one of the things I mentioned to pre-service teachers in my Introduction to Education course, is to never turn your back on this class. This communication that is provided by the building leader should include examples of appropriate and unacceptable observation methods. The third case was Munn versus Hotchkiss School. And in this case, it was a 15-year-old named Kara Munn who was attending a summer trip in China that was organized by the school. While she was there, which was a month-long process, she got a tick. That tick transmitted encephalitis, which in turn caused Kara to have a neurological damage, and she has since then been unable to speak. So Kara and her parents sued, arguing that the school was negligent under Connecticut law to have informed them that China does have the potential to have disease-bearing insects, and the teachers and supervisors in charge did not ensure that the students put on bug repellent as they did so, or the proper clothing. The jury did award $10 million and in economic damages and $31 million in non-economic damages to the family as a result of this case. Some reactive measures. I believe it's important that when you're going overseas, especially China or anywhere overseas, that you look at the procedures and the immunizations that are needed. You have to figure out what are the safety things that go along with this. So if, in this case, it was 10 days later before they took her in, when she knew right away that there was some itching going on in her arm. But it was 10 days later when she was doing more severe consequences or side effects that they finally took her in. So once that occurred, I would have hoped that my sponsors would have informed me of that. I would have done some research on my end of what things that needed to happen and shared that with them. Since it was a month-long process, it would be important to stay informed with that. Some proactive measures would be to sit down with the sponsors and go over expectations, and then look at the precautions that I kind of mentioned before about disease. The fourth one is a Kansas case, and this is Nichols versus USD 400. And in this case, Jeffrey Nichols was running from the practice field to the locker room at the direction of this coach, and he ran into a waterway. The waterway is the drainage part to the school's playground area, and he kind of tripped in that process and felt pain in his back as a result, and he filed suit against the football coach for being negligent about that. The football coach is considered an employee of the school, and the parties agreed that the coach did not intentionally injure Nichols. So as a result, the district court granted summary judgment in favor of the school district in this case, based on the discretionary function of the Kansas Tort Claims Act and the Water Recreational Areas Act of Kansas. Some things that I would do in reflection. First of all, I would need to investigate the drainage area and interview both the coaches and some players. As a building leader, I would make sure that I communicate expectations with coaches. Since it was done at dark, I would have checked at what time practice was going on. Since I also knew that there was drainage issues, I would have worked with the grounds crew to make sure this area was properly maintained. The fourth one is NM versus Anchorage School District, and this is a young boy, initialed NM. He was a kindergartner running to his mom at the end of the day, very excited, and he tripped and fell. He landed into a clump of pine shrubs, and they basically poked into his eye socket and into his brain and caused a traumatic brain injury. So the family did take them to court, claiming negligence for allowing the stumps to remain on a path that was heavily trafficked. The Superior Court found that the district was negligent in this case and was held liable. Some reflection from this case. My immediate reaction is to provide medical care to the child. Then I would investigate the event and determine any other plans of action to improve the area. I would also know that it's important in my proactive measures to be aware of my school surroundings, and I have worked with grounds crews to ensure the area with high foot traffic is maintained and protected from possible injury. All of these cases, or any tort case, really relies on teachers to follow procedures that have been established, communicate issues, whether they're good things, whether they're concerns, they need to be communicated. And everybody needs to be informed of what practices are best to suit the safety of our students and keeping them from harming themselves, but also keeping the teachers from potential liability issues. The next slide is just kind of my references for the court cases that give you a little bit better breakdown on them and understanding all that legal jargon. And I look forward to seeing everybody else's. Thank you.